Okay. A very good evening to the attendees, to Young Arif and my fellow panelists. Thank you to BicTok for the invitation to speak on this, I must say, not often discussed topic in arbitration, and how I propose to approach the next 15-20 minutes or so is by posing questions and then answering the questions in the hope that we get basic understanding of what taxation of course in arbitration is and how the courts have interpreted an application for taxation in costs in relation to arbitration proceedings. So, okay. The term taxation is typically used to describe the quantification or assessment of costs in legal proceedings. In arbitration proceedings, taxation involves evaluation of reasonable and appropriately incurred costs within and incidental to the arbitration proceedings. So the arbitral tribunal may tax or settle the cost of the arbitration proceedings, and it is also empowered by the Arbitration Act 2005 to do so, subject, of course, to any agreement between the parties, providing otherwise. So now, what happens in practice? You have the arbitration proceedings, you have now completed hearing, and you are at the written submission stage. You've just submitted your written submissions, and typically what would happen is either you would put in your written submissions. Sorry, I'm getting some feedback from the participants in terms of the sound.
There's a lot of echo and background noises.
That's right.
Can we please request that everyone mute their Tuling, are you able to mute it as the administrator?
Yes. Not. All right. I think it's
okay.
Good now.
Yes. Thanks a lot. Sorry for that. Yeah. So as I was saying, what typically happens in practice is that at the conclusion of the hearing and when parties are putting in their written submissions, parties would typically also submit on the costs that they have incurred in the arbitration proceedings. So from my experience, it's either the parties will write to the arbitrator and say that, okay, parties are now wanting to submit on costs and to get further directions on the filing of the submissions, specifically in relation to costs. Alternatively, the tribunal itself would give directions when giving directions for written submissions to also include submissions on costs. And that is how it's typically done. And then both parties, of course, will put in all the relevant particulars in relation to the costs incurred. Insofar as the typical costs that would be incurred and would be set out in the written submissions would be the costs incurred in engaging lawyers. If it's a technical arbitration and experts have been appointed, then the appointment of the experts, all the fees involved. And insofar as the running of the arbitration proceedings itself, we have room booking charges, the arbitrator's fees, the administrative body's fees, transcription charges. So it will be a whole host of things. And these are then listed down together with supporting documents. So we actually will attach the proof of payments, the invoices, to enable the arbitrator to ascertain the cost or tax the cost. So that's how it's typically done in arbitration proceedings. Now, let's look at some more common instances in which taxation of costs is done. And I think what would be good is if we can look at case that I thought would be useful. Just give me 1 second. Okay, so this is the Court of Appeal case of SDA Architects and Metro Millennium Sendirian Berhad. And in this case, the court discussed the tribunal's powers as well as the court's involvement in taxation, of course. So just to give you a bit of background facts, in this case, what had happened was the appellant was appointed as the respondent's architect for a housing project. So disputes arose in relation to payment of fees, and the matter was then referred to arbitration. The appellant architect claimed for approximately 1.2 million ringgit, and their claim was based on the rules, the architect's scale of minimum fees rules. The respondent, on the other hand, contended that the fee should be calculated on an agreed formula, which, according to the respondent, the parties had already agreed on, which would result in a lower rate. I recall the facts was 2.5% of the total construction cost. So now there was a difference in so far as how the fees ought to be calculated. The arbitrator agreed with the respondent and allowed the claim, the architect's claim, based on the agreed rate of 2.5 basis. And what that resulted in is a lower amount being awarded to the appellant architect compared to what was claimed in the arbitration proceedings. Insofar as cost is concerned, the arbitrator decided that the respondent would bear and pay the appellant's cost upon a party and party basis. So the respondent was not satisfied with the award of full cost that was awarded by the tribunal. And the respondent's main argument for that was because the respondent said, you claimed for 1.2 million. What was received was about half of that. How is it that I now have to pay the entire fees, the entire cost of the arbitration proceedings? That was the main complaint. So then what the respondent did was file a Section 42 application in court. Section 42 of the Arbitration Act is now repealed, but what it relates to is where one party is filing an application in court to refer questions of law arising out of the award. So this was the application pursuant to which the respondent had challenged the award of cost. The High Court agreed with the respondent and held that the appellant should not be entitled to full cost, but only 50% of the cost of the arbitration proceedings. The appellant architect then appealed to the Court of Appeal, and this appeal was allowed by the Court of Appeal. So in arriving at the decision to allow the appeal, the panel of 3 judges delivered separate grounds and allowed the appeal on somewhat different basis. So the 3 judges, I will very briefly touch on what each of the judges said and focus on one particular judge for purposes of this discussion. The first judge, Justice Muhammad Hishamuddin, as he then was of the view that the question of law itself was not a proper and valid one, and for that reason, set aside the High Court order. Justice Azia was of the view that the particular question of law posed in relation to the award of cost was a valid question of law, but that upon analysis and upon looking at all the documents and the arbitrator's findings and reasoning, came to the conclusion that the arbitrator had not committed any error of law in awarding the full cost in favor of the respondent to the appellant. And finally, the third judge was Justice Hamid Sultan, as he then was, and he also allowed the appeal on the basis that the court did not have the jurisdiction to interfere with an award on costs made by the arbitral tribunal pursuant to the Arbitration Act 2005. So I will be revisiting this case as we go along in the presentation, but I just wanted to focus on Justice Hamid Sultan's point. The judge noted that it is well settled that in the scheme of Arbitration Act 2005, the avenue to intervene, for the court to intervene, is limited and prohibited. And the court then referred to Section 8 of the Arbitration Act, which provides for this. The court also went on to say that the Arbitration Act in itself specifically states that costs and expenses of the arbitration shall be at the discretion of the arbitral tribunal. And Section 44 of the Arbitration Act in particular only allows an application to the High Court to tax costs in limited circumstances. So what the court was basically saying is that the discretion to award costs lies with the tribunal, the arbitral tribunal, and unless, of course, parties agree otherwise. Insofar as the court's role is concerned, it's more of in a situation where parties have requested to the court to carry out taxation. And I will come to that, I'll come to the circumstances in which this can be done. And finally, the judge also clarified or commented that taxing of costs in the context of Section 44 of the Arbitration Act means assessment of quantum of the cost. And it's actually different from apportionment of costs, as was done by the learned High Court judge in the instant case, where the learned High Court judge agreed with the appellant and halved the cost that was awarded by the tribunal. So now let's look at the interplay. What then is the interplay between the role of the court and arbitral tribunal for purposes of taxation of costs in arbitration? In our earlier discussion, a couple of minutes ago, we discussed and we established that the tribunal is empowered to determine costs, and that is settled unless otherwise agreed by the parties. And this is expressly provided in Section 44(1) sub A of the Arbitration Act 2005. But what then happens when the arbitrator has not specified the amount, but has only said that party A is to pay party B costs? So let's say in the award, the arbitrator or the tribunal has decided that which party is supposed to pay the cost, but then has not gone one step further to ascertain the amount. Now, this scenario squarely falls within Section 44 of the Arbitration Act. In a situation where the arbitral tribunal has directed payment for costs and expenses, but did not specify the amount in the award, then what the parties can do is make a request to the tribunal to do so. So this is provided in Section 44(1)(b) of the Arbitration Act 2005. If then within 30 days of that request, the tribunal fails to do so, then either party can apply to the High Court for taxation of costs. So that is basically how the tribunal and the court's role is different when it comes to taxation of costs in arbitration. Now, let's look at the case that I mentioned earlier, the Court of Appeal decision. We go back to the SDA Architects case. In the earlier case of SDA Architects that we discussed, the facts that I presented to you, the judge, in addressing the interplay between the courts and the tribunal, noted that when it comes to determination of the cost, that the court's role to decide on the cost or quantum of an arbitration had been specifically taken away by virtue of Section 8 and Section 44. And the court added that this particular restriction is impliedly recognized by Order 59, Rule 2, Sub 2 of the Rules of Court 2012. So what Order 59, Rule 2, Sub 2 provides is that it grants the High Court the discretion over costs from proceedings before an arbitrator or tribunal, unless otherwise specified by any written law of the Rules of Court. The court then also made reference to Order 69, Rule 2(1) of the Rules of Court. So Order 69, Rule 2 of the Rules of Court sets out the relevant arbitration claims that are admissible to the court under the Arbitration Act 2005. And what the court noted was that under Order 69, there is no reservation of right for the High Court to review or decide on costs handled by arbitrators under the Arbitration Act 2005. So in other words, the court was of the view that the arbitral tribunal will award a cost and the arbitral tribunal's decision to award cost and quantum falls outside the court's jurisdiction, save for taxation of costs as provided in Section 44 of the Arbitration Act 2005. So now if we were to look at or ask ourselves, so what then must a party do? Must a party first apply to the arbitral tribunal to tax costs before resorting to court's taxation power? Let's assume the example that I gave earlier, where the tribunal says party A pays party B costs and there's no amount stated. Can the party go immediately to the court and ask the court to tax that cost or determine that cost without first asking the tribunal to do so? And if the tribunal refuses to do so, does that then mean that court has to step in, or is the tribunal is compelled to determine the cost? This issue was discussed quite extensively in the High Court case of SQA Builders Sendirian Berhad and Luxor Holding Sendirian Berhad and another. So the facts of this case are quite straightforward, but I'll just give you a little bit of background. So what had happened was SQA was appointed by Luxor and another entity, Luxor YRM, as the contractor for certain construction works in a development project. Disputes arose between parties in relation to the work done and non-payment of the work done, which then led to arbitration and adjudication proceedings. So in the arbitration proceedings, the arbitrator allowed the claims in part and further directed LH and LY to pay costs to SQA. And if the cost could not be agreed, the court shall be taxed on a party-to-party. The cost shall be taxed on a party-to-party basis. So this was stated in the arbitral award. Now, against this backdrop, several applications were filed in the High Court, including applications to refer questions of law pursuant to Section 42, counterparty applying to enforce the award, and there was a separate application for taxation of the arbitration costs. For purposes of today's discussion, I will focus only on the application for taxation of costs. Now, after what had happened in so far as the arbitration proceedings and the taxation of costs is that after the delivery of the award, SQA's solicitors had applied to the arbitrator for the arbitrator to tax the costs after the arbitrator had stated what he did, as I mentioned earlier in the award. This was objected to heavily by the other side on the grounds that the arbitrator was actually functus officio after delivery of the award and could not tax costs and others. So in response to this application and objection, the arbitrator responded and urged parties to apply to the High Court for taxation of costs. So now the court addressed this question that I just posed to you. The court was of the view that an arbitral tribunal has a statutory discretion, a discretionary power to tax arbitration costs under Section 44(1)(a)(2) of the Arbitration Act. And as a general rule, the court was of the view that the arbitral tribunal's taxation power should be exercised first. And the court gave three key reasons for this. Firstly, because the arbitral award made by the tribunal is binding, and this would also include the award on costs. And once the tribunal decides on costs, the parties have no right to appeal to the High Court against that particular award. Secondly, if the tribunal's taxation power is not invoked, the court's taxation power has to be resorted to, and the court emphasized that the court's taxation power is not an optimal use of the limited judicial resources. And thirdly, the court noted that as between a tribunal who has conducted the arbitration proceedings and the court, the tribunal is in a far better position than the court to tax arbitration. And some of the reasons given was because the tribunal had the first-hand knowledge and which would greatly assist the tribunal itself in assessing the cost. So in summary, the court, or to answer this question that's posed to you, in summary, the court was of the view that the tribunal should have taxed the cost, and his refusal to do so amounted to an abdication of the arbitrator's statutory discretionary power, and the court rejected the arbitrator's views. So My question or my thoughts about this case is that how do we then explain, in light of this decision, how do we then explain the express wordings of Section 44(1)(b), which simply provides that if the tribunal is not willing or not agreeable to tax the cost, any party may then immediately apply to the High Court for taxation of costs. There is nothing in the Act that expressly compels the tribunal to first decide before an application can be made to the High Court. So that's something that we can think about. I am conscious of the time and I have two other speakers after me. So I will skip this slide, but just very quickly, this question was also answered in the same case, is the question being whether the arbitral tribunal is functus officio after delivery of the award. And the court answered this question and said that that's not the case, because insofar as the statutory discretion to tax the cost, that is still with the court, the tribunal can still decide on costs, and that is not something that is taken away, and it doesn't mean the tribunal is functus officio when it comes to that. There is one last point that I'd like to address before I end, which is what is the applicable criteria when undertaking taxation of costs. We have discussed extensively some of the principles and the interplay between the court and the tribunal's role, but one question remains: what does the tribunal or the court look at when undertaking taxation of costs? So the tribunal will likely follow the guiding principles provided in the institutional rules. For example, in the BICM arbitration rules, the rules provide, Rule 31 provides that the tribunal shall fix the cost of the arbitration unless otherwise agreed by the parties. And the rules then go on to provide how an apportionment can be done by the tribunal and some of the considerations that can be taken into account by the tribunal when determining costs. When the court is undertaking taxation of arbitration costs, the court would typically rely on Order 59, Rule 16 of the Rules of Court, which sets out the relevant circumstances. And there are various considerations, and I do not propose to go into all of them, but some of the ones are such as complexity of the item or cause of matter, the number and importance of the documents, and skill, specialized knowledge that had to be used. So these are some of the applicable criteria. And Thaya, I think I will stop there for now. If there is more time later on, then perhaps I can answer more questions in relation to the applicable criteria, because I'm mindful of the time as well, and to not run too much into my other panelists' time.
Yes, thank you very much, Loshini, for that excellent introduction to Section 44, the interplay between the courts and the arbitral tribunal, and the decisions in SDA architects and SQA builders, as well as identifying the applicable rules under BICAM's arbitration rules. Thank you for that. Ladies and gentlemen, we now move on to our second speaker, who will be discussing, Crystal Wong, who will be discussing provisions of the Arbitration Act on cost, but particularly in relation to Calderbank offers. Crystal is a partner of Lee Shamuddin Allen and Gladhill and has an active arbitration practice throughout Malaysia, Singapore, and the ASEAN region, with an emphasis on electricity, conventional and renewable energy generation, water supply, and complex infrastructure and engineering projects. She is a trusted advisor to clients comprising utility companies, independent power producers, government-linked companies, and multinational companies. Crystal is a fellow of the Chartered Institute of Arbitrators and sits on the panel of arbitrators of the AIAC and other arbitral institutions. So yes, Crystal, if you can proceed with your talk now on Calderbank offers and other aspects of the Arbitration Act on costs.
Great. Thank you. Thank you, Taya, and thank you, BICAM, for the invitation. Really grateful to be here, and good afternoon, everyone, or good evening, close to. So my 50 minutes will start now, and today we're going to delve into the strategic intricacy of arbitration, focusing on, for this particular 15 minutes, on a potent tool often overlooked in the legal proceeding or in arbitration proceeding called the bank offers. Why I say often overlooked is because myself, being in practice not too long, over the past 10 or 15 years, I've only used quarter bank offer once in arbitration proceeding, but it was, I would say, a bit of an experience because it was pretty successful, and I will share a little bit more about that later. So when you are a seasoned practitioner, whether you are seasoned practitioners or budding legal minds, understanding the nuance of quarter bank offer and how you can utilize it can actually significantly enhance your strategic prowess in arbitration, and also helping your client to achieve the outcome perhaps that they want to achieve. Starting first, slide 1 itself, where we talk about quarter bank offer. Many of us heard about this when we were studying because it's originated from English litigation, the case of quarter bank against quarter bank 1975. And this offer actually provides party with a discrete avenue for a settlement negotiation. And how does it work? It's under the veil of without prejudice, safe as to cost. And the unique blend of confidentiality and cost consciousness set quarter bank offer apart from other tools and set it as a potent tool, I would say, in arbitration itself, where parties will focus their mind. So next slides, we'll see that in litigation itself through courts, often since the quarter bank offer, the practice of settlement offer is long established. If you see in a rules of courts, you see in CPR, UK Evidence Act itself, all these actually set the ground for how quarter bank offer works and how it binds parties. But in an arbitration where the arbitral tribunal are not bound by Evidence Act or the rules of evidence prevailing in courts, especially at the seats of arbitration, then what is the effect of quarter bank offer, or how can an arbitral tribunal use it, parties utilize it, a counsel advise clients? So when we are looking at quarter bank offer, the first thing that we usually zoom into will be the Enabling Act itself. When I say started out from the UK, but if you look at the Arbitration Act 1996 of the England, you will say that there's no mention of quarter bank offer. But notwithstanding that, a lot of time when we read books, either Redfern or the specific book on cost of arbitration, they will say that tribunal are given wide discretion in awarding costs to the parties. And the big question mark would be, do you look into quarter bank offer? So in a general statement, that a still offer is an arbitration equivalent of pay-in costs is a misnomer. Though in the very few international arbitration acts, when we say lex arbitrary makes specific reference to a still offer, in general, you don't actually find them. But what we have this still, and it will be before you, you will see that the Malaysian Arbitration Act, Hong Kong Arbitration Ordinance, as well as the New Zealand Arbitration Act actually provides for quarter bank offer or mechanism akin to quarter bank offer. So I call these the exceptional examples of latest development in Arbitration Act, and you can see that in Malaysia, Hong Kong, and New Zealand. Starting from Malaysia, if you look at Section 44(2) itself, it provides for the mechanism of quarter bank offer, the pressure point, if you like to put it. If the offer is rejected, the outcome of arbitral proceeding is not more favorable to the parties that should have accepted the offer in the first place, then the party will have to bear the cost of the offer from the date of the offer. Therefore, parties will be encouraged to consider carefully if they're confident they can get a higher monetary outcome in the arbitration proceeding itself. And if they are not confident, they will be pressured to accept the offer. And if you look at subsection 3 itself, it provides for the without prejudice factor. So the quarter bank offer will not be reviewed to the arbitral tribunal until the conclusion of all aspects, especially the substantive merits of the proceeding itself. And the rationale will be to extend the privilege offer is to prevent the arbitrator or arbitral tribunal to be biased or swayed, is aware of the existence or the offer making this offer. And you will be preventing these statements or offer made in the course of negotiation being brought before the tribunal, because that will probably be seen as an admission of liability or quantum. One thing they have to bear in mind, Section 44 is actually Part 3 of the Arbitration Act, which means that it would apply only to domestic arbitration. For international arbitration, unless you opt in, otherwise this section is only available for domestic arbitration. I think that's something that we need to bear in mind. In relation to the Hong Kong Arbitration Ordinance itself, there is a specific reference to settlement under Section 74(2), which provide discretionary power to the arbitral tribunal in portioning the cost of arbitration. And the word used here is that the arbitral tribunal may, having regard to all circumstances, including that written offer of settlement, direct in the award itself to whom and by whom and in what manner the costs are to be paid. So in this situation, it's not a situation where shall. So basically, you must be affected by the quarterback offer. You must consider as a whole, not to say as a whole, consider and be bound by the effect of quarterback offer principle. But it's a situation where you may, if appropriate, take into account. And if you go to the next slide, you will see that New Zealand Arbitration Act 1996, as updated recently, it's more, to me, it's more mandatory phrase. It's probably the party shall be taken as having having agreed that the entire effect of quarterback offer, and then go on to the arbitral tribunal in fixing and allocating the costs and expenses of arbitration may take the fact of the offer into account in awarding costs and expenses in relation to the period of making offer up until the end. So I think it's quite clear from the wordings that the New Zealand Arbitration Act and the Malaysian Arbitration Act have systematically enshrined the principle of quarterback offer or seal offer mechanism into their national enabling legislation. While the Hong Kong Ordinance, though not in prescribed manner, it implies similar practice in a less tightly worded form. So just for completeness, if you look at the AIAC rules or the BICAM rules, of course, they don't provide the word quarterback offer, but both actually sets out the principles of cost follow the event, and the discretion is given fully to the arbitral tribunal to portion costs, where of course the quarterback offer may be taken into account. And of course that you look at the law at the seats of the arbitration. If you look at more loosely in an ad hoc arbitration situation, in Article 42 of the Ancestral Arbitration Rule itself, just like common law practice, same thing. Costs of the arbitration shall be borne by unsuccessful parties. So there's no specific reference to still order mechanism or any other method of apportionment, but the tribunal is given wide discretion. Why are we talking about this topic? In the next slide, you will see us setting out the advantages of quarterback. So we talk about AIAC rules in the absence of mention of quarterback offer, UNCITRA, same situation. So in the next slide, you will see that we'll just set out the brief advantages of quarterback offer so that you are mindful of this and can advise the client perhaps or learn more about this. Briefly, protection of prejudice is confidential, so it shields parties from being prejudiced, from prejudicing their arbitration stance. Cost protection, you can mitigate any financial risk from cost perspective by initiating such settlement discussions early and potentially avoiding hefty, what we call high arbitration costs, either from all aspects, tribunal costs, experts, and also legal costs. Incentive for settlement, the cost consequence incentivize often parties to engage in proper and earnest discussions and fostering speedy dispute resolution. So those are things that are often the reason behind advancing quarterback offer at the right time. Next, we're going to look at some of the case law because lawyers, right, and learning from Loshini. So we have outlined a few cases which we think is pretty interesting and something that perhaps you need to bear in mind when you are advancing quarterback offer in the manner that you want to put forth this kind of offer. So the first case is actually a Malaysian case where a party chooses to defer abstain its cost submissions during the arbitration because there's a quarterback offer situation and they want the quarterback offer effect to be taken before making any submission. So in this arbitration, the claimant choose not to submit its submission on cause in a written submission form, and also not to submit on cause in response to the respondent's cause submission. Instead, basically, they apply or they inform the tribunal that they will postpone the same until the tribunal has decided on the principal disputes and the difference between them in a written form. So the respondent in cause submissions, amongst others, sought an order for an adverse cause against the claimants in refusing a quarter bank offer, which the tribunal granted. And of course, facing with this outcome, claimants applied to the High Court to set aside the award, and of course citing breach of natural justice because there is no submission from the party. And the court held that paragraph 31 to 34, as the arbitrator is the master of the procedures in arbitration proceeding and subject, of course, to the applicable arbitral rules, parties are expected, as always, to submit their submissions and substantiation for their cause, including rebuttal submissions to the opponents or opposing sides' cause submissions to the arbitrator. Here, having given parties the opportunities to make their submissions and the party chose not to do so and to defer its submissions without consensus by both the respondent and arbitrator. Of course, there's no such denial of natural justice. Short takeaway point is that regardless whether there is a quarter bank offer situation and you do not want to be tainted by the effect of the perhaps the effect of the quarter bank offer to the cause award, you should not, for whatever reason, defer or abstain from making any cause submission. In fact, you can actually put in the permutation, perhaps taking into account of quarter bank offer, what would be the outcome, or the quarter bank offer effect should not be taken into account for whatever reasons. So that would be a more prudent manner to advance the case. Next case is the case of Leasings. It's actually a case that involved a dispute. One page before. The case is actually involved a dispute between claimants and respondents regarding a subcontract work carried out. Okay, so this subcontract work, the dispute under the subcontract is being referred to an arbitration, and during the arbitration, the respondent actually make a quarter bank offer to settle all claims in arbitration, and the amount that we're looking at is 77,000 only, and this, of course, payments. And the arbitrator awarded claimants a lower sum, which is 52,000. So there's a delta of 27,000, less than the amount that's being offered. Of course, in this situation, the arbitrator make the cause order against the claimants because the claimants is the person that refused the quarter bank offer. But the claimants in this case argue that the respondent was successful only because amendments to the defense was actually being made. Of course, when we read this case, we're saying that, so are you saying that no amendment is supposed to be made, or there should be a time where the pleadings is closed, and whether the amendments can be made has bearing with whether there's a quarter bank offer. I think that is the situation here, because the claimant is saying that if I know of this amendment at the time, I would have accepted the offer. Because the facts in this case is that the amendment itself, from the claimant's perspective, is that the amendment itself actually increases the respondent's chances of winning. So therefore, that has a bearing on whether they are going to accept the offer. But the court held that amendment actually made no difference, and the claimant would have rejected the offer in any event, even if the defense had already been amended when the offer was made. So in this case, the defendant's amendment lead to a reduction in the sum awarded. It's usually fair to award costs to the plaintiff. But the court also emphasized in this situation, it's important to consider what the result would have been without the amendment. So I suppose the court is looking at the effect of the amendment towards the outcome, whether it has a bearing to the tribunal's decision in this case. In this instance, the court is of the view that the amendment has no bearing to tribunal's decision, and therefore it would not affect the quarter bank offers, the application of the quarter bank offer principles by the tribunal. So where a party make a quarter bank offer relatively early in the proceeding, I think it's important for the party considering the quarter bank offer to apply their mind as to whether there's a shift in terms of the position and whether it's good for them to perhaps reverse the quarterback offer in that regard. Next, we're talking about Singaporean case. I think I'm mindful of my time. This probably will be the last case that I'm going to talk about. So next, we're talking about Singaporean case CKR contract services. That's 2020 Singapore High Court. In an arbitration, the contractor won the arbitration against the employer, although the sum awarded to the contractor was less favorable than the quarterback offer offered by its employer. Accordingly, the contractor was ordered to pay costs and was dissatisfied, and then the contractor appealed, and framing this issue as a question of law. I think this case itself is being talked about a lot in town, whether the application of the law or principle of quarterback offer can be framed as a question of law, or actually it remains a question of facts, mixture of facts and application by the tribunal itself. So it was held that a question of law is different from questions of application of law, as in how the arbitral tribunal apply the law of quarterback offer. In this case, the contractor was not dissatisfied with the the law of quarterback offer or the principle of quarterback offer, but instead it was dissatisfied about the application by the arbitrator on the quarterback offer. Hence, this appeal cannot be considered as a question of law. So there's no prohibition per se for the tribunal to consider the quarterback offer. And that also includes the settlement of other legal proceeding not before that particular tribunal. In this case, the relevant quarterback offer constitute a full and final settlement of the arbitration and related claim in other proceeding. So regarding the contractor's framed question of law on whether the tribunal can consider a quarterback offer where the offer seeks to settle a non-monetary claim that was pending, the court held that the non-monetary claim in the question had already been disposed of, and the tribunal cannot shut its eyes to a quarterback offer, and the determination of the question will have no bearing on the tribunal findings. So in this situation, focusing only just on point one itself, the parties should have bear their mind the threshold, of course, as usual, to appeal on question of law is high, whether it's in Singapore or Malaysia. But more importantly, arbitral cost order, the arbitrator's cost order as the quarterback offer may be a challenging one to appeal on, because ultimately the decision of the tribunal turns on application of facts as opposed to the principle itself. So when we are advancing the arguments based on our framing quarterback offer, the outcome itself as a question of law, I think this case basically shines lights and say that, you know, there would be a high hurdle that to cross in order for us to reach to be successful in terms of setting aside or resist enforcement based on this ground. I will skip this slide and just go perhaps to sharing practical tips for the arbitrator perspective, because I think from parties, one slide before, from parties' perspective in terms of how to use it, we will always say, you know, go look for your lawyer, seek legal advice, early case assessments, when exactly you should put in your quarterback offer. I think the timing is quite important. But for arbitrator perspective, I think there are a few things that we should take into account, and not even when we are considering a quarterback offer. And this is actually taken quite a few bits of them actually from the CRL guidelines, where even if you are considering the quarterback offer, at the same time, there are other factors that should weigh in, especially when your National Enabling Act itself does not provide for a fixed framework of quarterback offer. So Arbitration Act Malaysia is safe, New Zealand Act is safe, but in other jurisdictions, I think more factors has to be considered alongside the principle of quarterback offer. So those that have been set out on the screen are some of the factors that I think is important. One other factors that I think has been considered by certain jurisdictions or write-ups is actually the jurisdictional culture of parties in civil law jurisdiction, whether they are aware of true effects of quarterback offer. I will just put this down so that you can give it give these issues some thinkings, and we can discuss further about this later. Thaya, back to you.
Thank you very much, Crystal, for giving us an overview of the provisions in our Arbitration Act, as well as in New Zealand and Hong Kong on Calderbank offers. It isn't something that is provided for in all arbitration acts, but these three jurisdictions do have provisions on Calderbank offers. And also thank you for taking us through the relevant authorities on Calderbank offers in Malaysia. We now welcome Associate Professor Darius Chan, who will be speaking on lacunas in the law with regards to taxation of costs in arbitration. Associate Professor Darius Chan practices as an independent arbitrator and advocate with Breakpoint in Singapore and Fountain Court Chambers in London. He is concurrently appointed Deputy Director of the Singapore International Dispute Resolution Academy, Vice Chair of the ICC Singapore Arbitration Group, and a member of the Singapore Academy of Law's Law Reform Committee. Qualified in New York, England, and Singapore, Darius has an active practice as an independent legal expert, and he has provided opinions for use in the Chinese, Swiss, and US courts. Additionally, he has been appointed emergency, sole, and presiding arbitrator in arbitrations under a variety of governing laws, including Malaysian law. Darius is ranked by a litigation star by Benchmark Litigation, a Band 1 Junior by Legal 500, and a Global Elite Thought Leader by Who's Who Legal Arbitration Future Leaders. So without further ado, Darius, if you can take us through the lacunas on costs.
Thanks so much, Thaya, for the very kind introduction, and thank you to BicTok for this opportunity. I'm not a Malaysian lawyer, so I'm very privileged to learn from my colleagues on the Malaysian framework. What I would like to achieve over the next 10 minutes is to raise two specific lacuna in the law in relation to costs. And what I hope you can take away from the next 10 minutes would be an understanding, at least a basic understanding of where the gaps are, so that when you next have to argue this issue, you are at least sensitized to how different jurisdictions have looked at this issue and what reforms may or could be coming, right? So let's jump straight into this. The two lacunas are actually quite practical in nature, right? So if you see on my slide, point number 2, if I successfully appeal against the tribunal's jurisdiction under the model law, and I trace that back to section 18.8 of the MAA, to what extent can I recover the costs incurred during the arbitration? Yeah, so I've managed to persuade the court that the tribunal has no jurisdiction. Can I tell the court, please give me the costs incurred during the arbitration? So that's one issue. Then the next issue is a similar issue. If I manage to set aside the award under the model law, and the Malaysian equivalent would be section 37 of the MAA, then to what extent can I tell the court, please give me the costs incurred that I've incurred during the arbitration? Let me first set the scene for each of these issues. So you see on this slide, the first issue, I've set out Article 16.3 of the model law, yeah, and the equivalent would be Section 18.8 of the MAA, BICAM Rule 17.4. That is a provision that gives a tribunal the power to rule on jurisdiction as a preliminary issue, right? And that any party, after receiving that ruling on jurisdiction, can appeal to the High Court to decide the matter. And the issue that this raises, yeah, Thaya?
Darius, I do
sorry, I haven't changed my slides.
To be
sorry.
On your
there you go.
Yeah. Okay.
Yeah. This is issue 2 and issue 3. Yeah. And on the first issue, I've set out Article 16.3, 18.8 of the MAA and BICAM Rule 17.4. Yeah, that relates to a decision on jurisdiction that has been issued by a tribunal. The issue that is raised by Article 16.3 and Section 18.8 is that the party who successfully appeals against the tribunal's jurisdiction ends up without a way to recover their costs incurred for the arbitration to date. Yeah, at least under the model law, courts appear to have no express power to make an order in respect of the cost of the arbitration proceedings following a successful Article 16.3 appeal. Now, I want to pause to add that it may be that if the Malaysian courts are confronted with this issue, they may possibly interpret Section 44 in a way that gives the court the power to do this. Yeah, I will be happy to hear thoughts on this particular point, but at least under the model law itself, and at least on my own plain reading of Section 44, this particular issue hasn't been contemplated. Okay. Now, even if this issue is contemplated, the question doesn't stop there, right? Let me go straight to this issue. Even if the courts are given the express power to award cost of the arbitration, right, which is what Section 44 does, yeah, there is limited guidance and there are practical difficulties that have been surfaced. And these practical difficulties are summarized as follows. Number one, differing legal traditions, differing practices. And this is not so much a problem when you've got a domestic arbitration and parties who are familiar with, for example, Malaysian principles of taxation, party-to-party costs, indemnity costs, etc. This issue of differing legal traditions and differing practices would be particularly acute when you've got international parties, for example, from civil law jurisdictions. We've never heard of P2P costs, we've never heard of indemnity costs, not familiar with the tariffs imposed by the courts. In such situations, people have questioned, is it right for a court in trying to tax the cost of the arbitration that we would impose the domestic tariffs, we would impose domestic principles on the cost of the arbitration involving international parties. Now, this difficulty is accentuated because it is not possible to refer the court to previous arbitral awards for precedents, just because those awards would be confidential in nature. Yeah, so these are two difficulties that have been raised. And there is also a complexity. There's also a complexity in a situation where, let's say, the tribunal had already assessed some of the costs, right? If the tribunal has already some of the costs, then there's a dilemma. On the one hand, the court can decide that it will make a fresh determination of cost of the arbitration for itself, right? Or it can rely on the assessment of the tribunal, but it is a tribunal that has been found to lack jurisdiction in the first place. Yeah, so the court has this dilemma. Do I assess the cost of the arbitration for myself? If I were to do it, then how appropriate is it for me to impose my domestic principles in an arbitration involving international parties? I do not have precedents that I can refer to. Or can I perhaps rely on an assessment that the tribunal may have done, and most tribunals would not have done it, right? When deciding on issues of jurisdiction. And if I were to rely on an assessment done by the tribunal, it is a tribunal that I've already decided, that the court has already decided that the tribunal does not have jurisdiction in the first place. Yeah, so these are some of the difficulties that have been raised. Even if the court has the power to tax the cost of the arbitration, in practice, how do we actually do it? Yeah, in practice, how do we actually do it? So the reforms that have been considered, right, at least in the Singapore context, is that some people have argued that we should make people file cost schedules setting out the cost of the arbitration before the result of the Article 16.3 application is known, right? Make parties set out their full cost schedules incurred in the arbitration right from the outset, right? Another reform that's been suggested is that we would tell parties in advance that the court may appoint a cost assessor, right? An independent cost assessor who would be more well-versed with the traditions of the parties concerned, and who may be able to assess the cost better than the judge. Now, some people have also questioned, if you're appointing a cost assessor, why don't we just go back to the tribunal, right? Because the tribunal would have heard the issue of jurisdiction in the first instance. But the Singapore courts, at least in Singapore context, the Singapore courts have very strong resistance against asking a tribunal to decide the point when it has already decided that the tribunal has no jurisdiction. Yeah. Now, a third reform that is being considered is asking institutions, right, to institute a practice that when a tribunal makes a jurisdictional decision, that the tribunal will decide and pronounce on the cost of the arbitration incurred up to that stage, so that the court doesn't have to do it at a later stage. Now, this suggestion, unfortunately, at least in my experience, has not been picked up by any of the major institutions. And the reason for this is the institutions have said that, look, once we constitute a tribunal, we let the tribunal run the proceedings, and we don't really want to interfere with how the tribunal would want to decide on the issue of jurisdiction and cost, etc. Okay. Now, I'm conscious of time, so in my slide, I've set out a sample cost schedule that people have advocated for that can be used when trying to help when trying to seek the help of the court to tax the cost of the arbitration. Now, moving swiftly to the second issue, which is quite similar, which is cost of the arbitration after successfully setting aside an award. Now, this issue is similar, but it's slightly more complex, right? Now, this issue is more complex because it may be a case where the setting aside challenge fails. If the setting aside challenge fails, then fine, right? The cost award can stand. That's not going to be complex at all. But what is more complex is a situation where the tribunal has made a cost award and the setting aside on the merits award succeeds. Yeah. So you have a situation where you've managed to set aside the merits award and the tribunal had also made a cost award. Now, at least in the Singapore context, the courts have said that, yeah, we would be able to set aside the cost award together with the merits award, but we don't have the power to issue a decision to award the successful party the cost of the arbitration. And here you see a passage where I've quoted where the court said, and in this case, this was Lord Mans of the SICC, the Singapore International Commercial Court, lamenting that it would appear to be a matter of regret if it was not possible for a party who's managed to set aside the award to get some kind of cost order for the underlying arbitration itself. Just a quick run through of what other jurisdictions are doing in this regard. In England, there are no provisions. So just like Malaysia, there appears to be no express provisions on this point. Yeah, Hong Kong, similarly, no express provisions. And the reason why there are no express provisions, at least in the Hong Kong context, is because the model law is silent on this, right? That's why there's a gap in the first place. In Australia, there are provisions, right? There are provisions that would grant the court the power to award costs in respect of the arbitration proceedings when the arbitration fails. So in Australia, that's different. So we can all take note of that. So moving on to my last slide, proposed reforms. Again, this wouldn't surprise any one of us. The proposed reforms that have been suggested is that parties will file cost schedules before the setting, together with the setting aside application, right? The court will appoint cost assessors who are more attuned with the legal traditions of the two parties. And the final one would be amending the statute to make clear that the court has the power to grant the cost of the arbitration in these two situations that are being discussed. So that's my 10 minutes worth of sensitizing you to these two gaps in the model law. And I'll be pleased to hear from you, whether today or at a later forum, on how the Malaysian courts would deal with these two issues. So Taya, back to you.
Thank you very much, Darius, for taking us through the various lacunas in the model law as well as in legislation, both here in Malaysia and in Singapore, with regards to costs. They primarily seem to arise in situations where the award has either been set aside or the tribunal has been found to lack jurisdiction. It would be interesting to see that the amendments are presently being considered to our Arbitration Act in Malaysia. And it'll be interesting to see if any of these sorts of amendments are made to Section 44 in relation to the appointment of cost assessors, the submission of cost schedules, or empowering the courts to deal with costs in these circumstances. So thank you very much. So thank you for all our speakers, all of whom have made their presentations. Are there any questions from the floor? I'm mindful of the fact that we've actually reached the end, or we were slightly past the 6:30 mark. But perhaps if there are one or two questions, we could take them. Are there any questions from the floor? None? Perhaps then I can just ask one or two myself. Crystal, you spoke of Calderbank offers. In practice, have you had any notable war stories where you've been particularly successful using Calderbank offers?
Yes, I do have one that I wish to share about, and actually it wasn't my credit's not to me, probably to the drafter of the agreement itself. So it's a very unique situation where the quarterback offer provision is actually in the arbitration agreement itself, and it's actually my first time seeing it in a local contract. So it's a government-linked company, an investor. The quarterback offer itself, the provision, the mechanism is set out in the arbitration agreement. So we looked through. We told our client that this is a small amount claim, double-digit millions. So it's in the region about like 15 to 20 millions. So we asked client, the client is the respondent in the situation where they will have to pay a certain amount in any event. So we basically asked them what would be the region in terms of perhaps in a situation where construction defects and you will be expected to pay a certain amount, and how much would it be? Realistically, an amount has been crunched by client, compared against a trade members tribunal and legal fees that you have to pay for arbitration. What is the amount? So we only reached a stage where pleading has been exhausted, and thereafter you'll be quite surprised to learn that usual arbitration proceeding will be discovery, filing your factual witness statements and all. But in this case, we actually adjourn the timeline, postpone the timeline, and resort to true and full quarterback offer being advanced. So the respondent sending the quarterback offer, the claimants then reply. Usually it's a situation where you reply with a counter offer, in the sense reject and counter offer. But this situation is they frame it as first quarterback offer comes in, rejected, and then second quarterback offer from the other side. So it's my first time encountering that, but then it was really successful one, because after exchanging for, I think, 2 quarterback offer from each parties, and in the end, parties managed to resolve the matter. So I suppose I would really advocate for a situation where your claim sum itself and the arbitration cost finality, one other aspect as well, when these 3 factors are being put together, and if it makes sense dollar and cents wise for you to move on with finality, then I think quarterback offer is really the way forward. So I only advocate for this issue or bring forward this case because the quantum in disputes and the arbitration costs are pretty close. So parties managed to cross the bridge and arrive at a good settlement with the help of quarterback offer. Yeah.
Thank you for that interesting war story. There's a question in the chat group from Justice David Wong. His question is, so it would be advisable for the tribunal to request cost submissions before handing down the award. And would anyone like to answer that question?
Yeah, I can do that, Thaya. So, Tan Sri, I think in my experience, what I have come across is the tribunal requesting for cost submissions before handing down the award, and also a situation where the tribunal will write to the parties and say that the tribunal is now ready to deliver the award, and ask parties to then put in written submissions specifically addressing the tribunal on the cost. because sometimes what happens is that they are unable to ascertain the cost at the first round of written submission stage, because you still have reply submissions, and if there are any further submissions that's requested by the tribunal. So what we typically do is, once we are certain that the tribunal is ready to deliver the award, then the tribunal can inform the parties to now put in their cost submissions, which the tribunal then can take into account for purposes of rendering the final award.
Thank you, Loshini. Are there any other questions from the floor?
If I may,
Yes, Judge.
it'll be interesting to hear as to how much cost, or the highest amount of cost that the practitioners have obtained. Because given the confidentiality issue, and as the professor have said, we don't have published precedents.
Yes.
Any of them,
everyone can give an indication within the bounds of confidentiality, without naming names. If you would, any of you would like to share the upper limits of cost awards you all have received. Darius, sorry,
yeah. I don't think I'd be able to divulge the figure because of the confidential nature. But what I can say is that in a recent arbitration award where we were successful, the tribunal allowed all the costs that was claimed arising out of the entire proceedings. It was a long arbitration proceedings, and it took several years. There were various experts involved, so the cost was quite high, higher than the typical arbitrations that would be that were concluded in shorter duration. And when we submitted on cost, we impressed upon the tribunal about the complexity of the matters, and in fact, we sought guidance from the rules of court insofar as the basis of assessment to explain to the tribunal why the client had to get this sort of expertise due to the technical nature of the matter. And the tribunal agreed and awarded the entire cost that was claimed, albeit it was quite a high amount. I must also add that in this particular arbitration, it was quite a clear-cut decision in the sense that a claim was made, we defended the claim, and we were successful. There wasn't a partial award in the sense that, the claimant wasn't allowed a partial amount and then only the balance. So I think in that case, it was easier for the tribunal to come to a conclusion on how much to allow.
Are you able to share as to whether it might be what, 500,000 in cost, 1 million in cost?
Josh, if I can just share with you, based on experience, most of the time, if you have Malaysian lawyer against a foreign lawyer, chances are the Malaysian lawyer will get their cost in full, in the sense that we are very reasonably priced. Yep, that's one thing. If you're comparing, I'm just comparing two awards that we have, and we can, I can disclose a little bit. It's because it's actually public listed company, so the award is actually out, and I'm going to name which company. So for two different independent power producer. The first one is when I started practice, it was like 2013. And the award that we get, the full cost that we get in terms of legal costs and plus a little bit here and there, is probably close to 1 mil. The recent one is because it's an ICC involving two sets at least of lawyer, one Malaysia-based, another one French-based. So the legal costs that we've incurred in total, including transcripts and everything, is about 15 mil.
How much?
15. Sorry, that is actually the total arbitration cost itself. Yeah.
That's very substantial.
Yes, it's not just legal costs. Yeah, sorry. It's not just legal costs, it's total arbitration costs, about 15 mil.
What about you, Thaya? Are you able to share?
I think the upper limits of the figures we are speaking of, my lord, would be in the region of the higher teens, 15 teens, millions in teens. But I think to be fair, all three of us, at least from the Malaysian perspective, Loshini, Crystal, and myself, I think we are all in construction arbitrations, which involve substantial amounts of money and very large volumes of documents and complex issues. And as you would notice, both from what Loshini and Crystal said, a lot of cost is also incurred because of the experts appointed. But I'm sure we can also hear from Associate Professor Darius, who I'm sure would be party to a lot of very high cost awards in Singapore.
Yeah, so it's not uncommon in proceedings involving international firms in arbitration seated in Singapore to have costs running to 10, 12 million. I've seen that, right? And the arbitrator will grant it. And this is a particular acute issue which has actually culminated in case law. And the case law involves a case where there was a 9-month arbitration before a sole arbitrator, and value in dispute was 1 million, right? 1 million Singapore dollars, 9-month arbitration. And the arbitrator awarded costs of 3 million to one side. So the party had to pay 3 million, appealed to the Singapore courts to say, look, this is entirely disproportionate to the value in dispute. And the Singapore High Court, looking through all the precedents and the model law, Travaux, etc., said, sorry, right? Just as the case that Loshini covered, once the tribunal has decided, the tribunal is given the discretion to decide, and we, the Singapore courts, do not have the power to disturb how the courts have how the tribunals have decided on costs. We don't apply the principle of proportionality. The tribunal doesn't have to apply the principle of proportionality that we would otherwise judges have to apply in litigation proceedings. So it is a big issue.
So I hope that answers your question, Judge.
Yeah. I wonder whether they have thrown in the access to justice into the pot in considering this.
Yes, certainly. I mean, I think where the costs are disproportionate to the value of the disputes, then there is there are constitutional issues as to access to justice which arise. And if there are no further questions, bearing in mind that we're now 15 minutes past the half hour, we should perhaps conclude our session for today. Thank you everyone for joining us, and thank you for all the questions. And thank you once again to our presenters who kindly have taken time off this afternoon to be with us. Thank you.
Yes, I'll echo the thanks. I learned a lot from this talk.
Thank you for joining us, Judge.
Thank you.
Thank you all.
Thank you. Bye-bye.
Thank you, everyone.